Could you give an example of an action, a Title III action that could be brought consistent with an exception under FSIA?
Sure. There are now 50 Cuban importers that import millions of dollars of goods from the United States, grains, chickens, all sorts of goods, under general licenses. They enter into a contract with an American exporter. The American exporter ships the goods. The Cuban importer pays the money to the exporter. That is a direct effect. All of those Cuban importers could be sued if they're using expropriated property. The ports, the docks, as we heard this morning, the airports, the warehouses, their offices, all of those are likely to be on expropriated property. That's one. Second, the case you heard this morning. Havana, when the cruise ships went into Havana, to the docks in Havana, there were 6 Cuban instrumentalities that either owned or operated those docks. Havana Docks could have sued any one of those. And there are innumerable cases. But the key point is that Helms-Burton gave the president the power to expand or contract the embargo. And various presidents have used that to either ease the embargo or expand it. And you cannot fix in time whether or not this was going to happen in 1995, 1996, or now. There has been an enormous expansion of trade with Cuba, and that expansion allows for the possibilities of many suits. But back to Justice Sotomayor's question before, I don't think this court can evaluate how many suits there would be, whether it's too few, whether it's too many, what to do about it if it's too few. That's the job of Congress. This court's job is to evaluate the text and see if there's an irreconcilable conflict. And as I think in their answer—